So I just want to start by saying that I'm very much approaching this from the perspective of sort of sharing my own experiences. Obviously working in a SaaS company with software as a service tools that are used by customers to collect data. So providing in that context my own experiences and my own understandings of GDPR obligations, as well as some context in terms of recent developments. I hope that's helpful to frame what I'm going to discuss. So this is the brief for this morning's presentation, and I've broken it up into looking at the technical privacy implementation requirements, security, pets, and privacy management platforms, then looking briefly at cookie policies and more specifically some recent developments in that area, briefly talking about data subject rights, and then looking at the case of the US in terms of the global challenge for implementing a privacy program. So we'll dive right into the technical privacy implementation issue. I wanted to start by just briefly acknowledging that there is a lot of challenge to technical implementation of privacy. As Magdalena mentioned, there's a lot of variance in terms of the standards that should be applied, in terms of what is considered to be acceptable or not acceptable from a regulatory perspective and from a customer perspective as well. Depending on the scope of your challenges, you may end up running into risks because you maybe perhaps try to implement things too quickly. You identify a challenge and want to rush to address it as soon as possible, because obviously the quicker you do that, the less hopefully risk you have. However, by rushing into implementing security protocols or technical measures that are supposed to help you, I think you can always run into issues like breaking systems that you already have inadvertently, introducing operability problems, and maybe avoiding the issue of getting employees on board to actually adopt what you're trying to implement. So hasten slowly, or festina lente, when you're looking at security tools and when you're looking at privacy enhancing technologies, because some of them may appear more beneficial than they actually are, and it's certainly it's better to do your due diligence and take a paced approach. So consider the scope of the challenges you have, balance what is the functionality that you're looking to achieve, the interoperability with your other systems, and the protection it provides. And then examine the hidden privacy and security risks. And what I mean by that is security tools and security solutions, as well as privacy enhancing technologies, can appear on first glance to have a great deal of benefit. However, they may in fact actually result in you collecting more personal data in some instances, or putting personal data in places that hadn't been before, or being used in a different way. So even with respect to security tooling and privacy enhancing technology, you do need to do your privacy impact assessment with respect to that. So just move slowly, do your ducks in a row before you move forward with any technology enhancements. So looking at security specifically, what do you have to do versus what matters to your customer? This is something that, especially in the SaaS industry, we experience a lot of. GDPR has obviously introduced a layer of complexity to management of customer data. And as a European entity, if you're collecting customer data or if you're using customer data, you have to give consideration to your obligations. But as a business, you also have to address what matters to your customers. It can therefore sometimes feel as though your priorities in the area of security are pulled in many different directions. And it's difficult to focus on what's important to your organization. This is when it's important to take a step back and revisit the actual text of GDPR for a sort of a reality check, and also just understanding what is regulatory. I recommend starting with the second two requirements in regards to the GDPR text, which is namely kind of taking into consideration the scope and nature of the processing activity that you're undertaking and the risk to the data subject. This can be more easily assessed once you have a clear understanding of the categories of data you hold as an organization. And I think a lot of organizations have already done this analysis in the run-up to GDPR, but it's obviously relevant to do it on an ongoing basis and continually recheck your analysis of the categories of data you collect. Categorizing the risk levels is critical, and you can use standards like ISO as a sort of a roadmap for categorizing your data, but that's not necessarily essential. It just provides a sort of a structure for that analysis. A lot of organizations will categorize data by function or purpose. So for example, if you have a lot of billing and financial information, you can categorize it by that function. However, obviously you have to start by categorizing individual data elements by their risk level. So I would start with that process first and then move them into their various functions after you have analyzed the risk factors for each category of data. That way you can take a step back and look at all the systems that you have which store data and identify all the systems in your visual map so that you can identify heat spots in those systems where there are security threats that tie to the higher risks of categories of data. There are, of course, many ways to address heat spots, and I've listed some of them on this slide: pseudonymization, encryption, and then there's obviously looking at what is industry standard and state of the art in encryption standards, for example, and whether or not you implement the highest standard will obviously depend upon, again, the risk level of the data in that system. There are, of course, many ways to address those heat spots outside of encryption, keeping things confidential, having access limitations, but it also entirely depends on your infrastructure as a business and other factors like your reliance on third-party systems and tools. Assuming you take a risk-based approach, then documenting those decisions is absolutely critical. I asked my own CISO last night when I was speaking to him what his 3 main recommendations would be to an organization looking at how to protect customer data. And interestingly, his answer was very elemental in the sense that he just said, you must first make sure you know where all your data is. And then know who has access to that data and continually review it. And then test your environment constantly, at least every 6 months and probably once a quarter, preferably, in different ways to make sure that the systems that you have in place are actually working. I was really surprised by how basic that advice was, but I think when you think about actually what you're trying to achieve, I think doing that is very iterative in nature, and it very much reflects the nature of things like ISO standards, where you do plan, do, check, act on a repetitive basis. So just moving on to some of the challenges that at least myself and my team internally has noticed in relation to implementation of security standards after the GDPR. Certainly certification standards are something that has become very much important for us as a business and for a lot of companies and organizations. We obtained ISO 27001 certification last year and are looking at other standards this year. And I think they do play a part in any organization, but it depends on your maturity as an organization whether or not you seek certification immediately or whether you first have some more basic things that you have to undertake as an organization. Things that you need to look at to determine whether certification is necessary are obviously your risk factors in terms of the data you're collecting. Your size and resources that are available to your business are relevant too. The regularity of security issues as a sales blocker is one that is really relevant, especially in an online environment. If you're trying to sell your business tools to other companies or directly to a consumer base, then if that's becoming an issue because of security and trust, then that definitely indicates that, you know, certifications can really be helpful in building that trust. And then the level of current maturity you have as an organization is also really important, because if you have a long way to go to bridge the gap for certification, then again, you may be better just starting from basic principles first. Another challenge that I noticed, and I think most organizations feel this, especially when you're growing, is training at scale for security and privacy. That's a huge challenge. And I can only share what I've seen work and not work. Repeated self-paced annual or biannual trainings are of themselves probably insufficient to get security messages across in an organization. Some organizations have looked at ways to spot check compliance with things like phishing attempts and gamification. These are not without their pitfalls either, as they generally sort of send a gotcha message to employees, as in we've caught you doing something wrong, but it doesn't necessarily reinforce the positive message of what is the correct steps to take. What has been demonstrably more successful in my experience have been programs that support team-level ownership of security compliance. This can involve more output to establish in terms of training. So what it means is establishing protocols and guidelines for a specific subset of individuals within teams who then partake in train the trainer and buddy systems, such that each team has individuals within their rank that have a deeper understanding of security rules at play. And then they continually share those out with evolving teams. This accounts for new hiring and onboarding and reinforces the self-paced trainings that you do sort of more for your tick-the-box process. Vendor management is another huge area that we've identified as a risk under GDPR from a security perspective, and it's obviously a major challenge for a lot of organizations. Every company struggles with it, especially when you're resource strapped. Ideally, you would be doing an intensive security review for every single vendor, but that is not always practicable or scalable. So going back to your data categorization is really critical. If you can map your medium and high risk data categories on your data map, you can also prioritize vendor review in that way. This also helps from the perspective of data minimization, because internal teams will come to learn that where they collect less data within third-party tools or less high-risk data with a vendor system, then their faster review process occurs for them and they manage to get onboarding the vendor quicker. Finally, privacy and security engineering is a burgeoning area, and I think hiring the people who have the right skills and experience to actually implement good security measures is very difficult. There's a limit of talent in this area, so when you can't hire, it's increasingly that there's a demand for off-the-shelf experts and solutions out there, and this isn't always without its own challenges. So we'll discuss that in the next slide. So looking to privacy-enhancing technologies, or PET, depending on how you refer to it. I find it hard to refer to it as PET, though, because it brings to mind my cat. It's not one single tool or application. It is generally understood to mean a combination of IT tools or engineering practices that result in enhanced privacy for the user, while still allowing the service provider to use the data for their business. Positive sum, not zero sum. They use various technical means in order to protect privacy by providing anonymity, pseudonymity, unlinkability, and unobservability of data subjects. Or in the alternative, you might have clear consent choices and workflows within your systems and tools. You might think this sounds a little bit like a new concept, but it's actually been around for quite a long time before GDPR came into effect. And it's something like basic security tools that access limitations apply, or where you simply define access to data by way of role. It also includes granular consent-based processing, where data subjects have the right to opt in or out of different categories of processing. How do you go about introducing privacy-enhancing technologies depends on the maturity of your IT infrastructure again, and the technology and engineering approach for your business depends very much again on the categories of data you collect, the criticality of your business model to have personal information as opposed to anonymized data, and then the risks that arise for use of that data. If you can, you should develop high-level policies around privacy-enhancing technology and build consideration for those into your product development processes and roadmaps such that they're not later tacked on as an afterthought. And I think if you can demonstrate that to customers as well, it again builds trust. The lawyer's role in this is obviously just an educational one in terms of advocating for consideration of things like anonymization, pseudo-anonymization. I always just revert back to asking the simple question, what do you actually need to achieve and what do you need to collect in order to achieve that? And by asking that, you start, getting into the details of what is important to focus on with respect to technology. If we understand the business imperative and the challenges, then it's easier to appreciate what's achievable. So to address the challenges of implementing PETs in your organization, I can attest that the start of the solution again is really having people internally who understand the imperatives. And if they don't, then that does create some blockers for you. Legacy technology and information systems can also be a big blocker for implementing privacy-enhancing technologies because they're not always interoperable or able to function together. But if you have the right knowledge base internally or through partnerships externally, then you can incrementally overcome, hopefully, those tech debt issues. So moving on to look at privacy management platforms, I think everybody will appreciate that prior to May 2018, we saw a sudden extreme rise in the existence of privacy management platforms. And then since then, it has just grown exponentially as a business tool market. And I think I'm somewhat skeptical of the use of these tools for end-to-end GDPR compliance. However, I do acknowledge the benefits they do have for certain organizations, depending on where you're at in your maturity as an organization for privacy purposes. Something that my CISO again said last night when I was discussing this with him was use what you have and use it well. So I think that's an interesting one because oftentimes we can sort of think, okay, well, we absolutely need to buy this end-to-end tool that will help us with our records of processing activity and help us with our data mapping and ensure that we're doing our privacy impact assessments. But I think if you look internally at the tools that you're using, some of those tools may already be in a good position to help you with those processes. So it's first looking at what you have before you move to the external market. But the pros of privacy management platforms certainly exist. I think plug and play is the assumption when you hear privacy management platforms. In other words, I plug it in, everybody gets on board and we all start using it and it's very, very straightforward. I don't think it's necessarily the case with privacy management platforms. They do involve a level of education and training. They do involve a level of adoption, but there is certainly an element of, it's built specifically for, designed to help you with your compliance, processes. So therefore, it does have an element of plug and play, but not entirely, as we'll see in a minute. Enhanced automation is certainly the case with privacy management platforms. However, I would say it's not end-to-end automation. Again, there's a lot of human element involved in any of these systems, and you do have to have full adoption. So expecting it to run in a fully automated fashion is kind of, it's probably not an accurate presentation of what actually happens when you start using these tools. And then scalability, I think, is certainly a huge benefit to using a privacy management platform, because it's easier to move from one level of growth and one level of data collection to the next level if you're an organization who is growing and who is looking at using data in different ways on an ongoing basis. So I think it is much more scalable to use something like this, depending on whether you already have a lot of systems and sort of legacy data systems in place. The cons, so I wouldn't say they're cons as such. That's probably not the right way to phrase it. I think it's more challenges that you'll have in using privacy management platforms. Definitely internal oversight is required for these systems. It would be enticing to be able to just provide your organization with a tool and say, now we are going to use these for our data mapping, for our records of processing, and you step back and don't need to look at it again. But I think there's a lot of scope for misuse and miscategorization of data within these tools unless it's being observed and constantly checked and tested. So you can have different teams inputting data in different ways. You would have to have a standardized data criteria input for the system. So I think it really has to be both fully adopted, which is the next point, but also well reviewed and well regulated internally. Cost is obviously a major issue with these platforms. They aren't cheap, and they certainly seem to sort of get more expensive as demand increases. So it is prohibitive for some organizations, depending on your size and your budget. I do think that there are some budget innovations you can achieve by maybe grouping together with other teams within your organization, but at the end of the day, it's not going to be a cheap investment. So if you're going to invest in it, I think making sure that your organization is all in terms of using it. If you have only sort of intermittent adoption of these systems, then they really don't pay. And I think looking back at what you have in your systems already in processes for actually, recording data, determining when data is high risk and things like that will be really important before you adopt something like this. Moving on to and away from the technical aspects of implementation, although cookie banners certainly involve a lot of technical implementation, we're going to look at cookie policies a little bit. And I've approached this from the perspective of just revisiting some of the case law from 2019 and then looking at some early developments in the first part of this year from the Irish perspective. I think probably most of you will be familiar with these cases, but it's worth just very briefly revisiting them in terms of the impact that they will have on what we see in the cookie space in the upcoming 24, 32 months. The Planet 49 dispute concerned the pre-checked checkbox for online promotional games, and the internet user who was wishing to participate had to consent to the cookies, but it was a pre-checked box. And the Court of Justice obviously said that that was not valid consent, and as such the consent required the user's active, not passive behaviour. I think this is kind of a verification of the Article 29 Working Party guidance on consent, so it's not that surprising, but it really did sort of was the final nail in the coffin, if you like, of implicit banner consent, the scroll and you've consented type banner. It applies irrespective of whether there's personal data being collected by the cookie, and the website provider must inform the user of the duration of the operation of the cookies, which again can be challenging for some people, some users, some website owners, especially if they've used a lot of third-party cookies and are heavily reliant on those cookies. Fashion ID was the other case, and while it didn't directly involve cookies, it's very relevant to cookie implementation, I think, just because it speaks to the issue of joint controllership with third-party vendors of cookies. This was the website operator who put the Facebook like button on their page or social plugins, and the Court of Justice deemed that any implementation of a plugin like that on your site meant that you were now a joint controller with the social media company that you're using. Interestingly, you didn't actually have to have the user click on the like button in order to become a joint controller. You're a joint controller by reason of the fact that you put the button on your website, which means that this is difficult for messaging and transparency when you're trying to create your cookie policies and trying to create your privacy notices for users, because even if your user isn't a Facebook user, for example, if there's a like button for Facebook on your site, then you automatically have to obtain their consent, notify them about it. Imagine the confusion of a user who hasn't actually used Facebook being asked for consent to share their data with Facebook when it may not happen unless they click the button. So that creates some difficulty for a lot of website owners, I would imagine. And then in April of this year, the Irish regulator, who's our lead supervisory authority here in Ireland, came out with their guidance on banner design requirements as well as consent requirements around cookies. This was an interesting one because they had done a cookie sweep last year and they had discovered a lot of non-compliance around cookie banners, and the indication is from the guidance note that there's now 6 months from April in which to implement any changes necessary by reason of the guidance. And I wanted to just share with you some of the guidance that they provided in terms of especially around user interface design for banners, because I think they gave surprisingly a great deal of granularity around the guidance for that. So banners obviously need to allow rejection of non-necessary cookies. You need to be able to reject them just as easily as you can accept them. And this is an interesting one because I think a lot of implementation of banner right now certainly gives preference to the accept button. For obvious reasons. And so what they're now saying is you have to give equal prominence to the reject button. It's not entirely clear if they expect all websites to use the word reject or whether other language, other words can be used. There doesn't seem to be an awful lot of wiggle room in terms of the granularity of the guidance that they're giving. And then a second layer of information must be provided with more detailed information about the types of cookies, the purpose of the cookie, other technologies being set, and the third parties who will process that information. So a great deal of due diligence will be required, I think, to actually comply with that, which is a good thing, hopefully. It must provide users with options to accept or reject the cookies. And then checkboxes or sliders must be set to default off. I think this one was surprising that they were very overt about this and were very clear that everything should be marked to on or off, and off being the default for anything that is non-essential. I think it's also a question mark over whether they'll accept other language again or whether on and off are the only language that they'll accept in a radio buttons type scenario. Users must be able to change their cookie preferences at any time, and consent must be renewed every 6 months. So again, you're going to have to revisit your banner and review your banner to website users every 6 months at a minimum. I think that's potentially going to result in yet more cookie fatigue, but it's hard to tell. Some websites have definitely gone towards using a cookie banner every time a visitor revisits their site. So it may be that it's just something that some Irish companies will have to adapt to. In terms of the trends around cookies, I think we're seeing a slow improvement in the standardization of banner implementation among CMPs. I think it's relatively safe to say we will see the end of the implicit banner if it already hasn't happened. Unticked boxes will likely become the industry standard with defaulted to off. CCPA may be pushing some changes in this department, especially given some of those vendors would traditionally have managed data predominantly to a US standard as opposed to a European standard. So to a large extent, until there's a complete overhaul of the current ad tech business model, I think addressing banner implementation on a website by website basis is a little bit cart before horse, but I think probably it's just the most tangible thing regulators can immediately address right now. Will implied consent banners go away? I think they will, for sure, in the next 12 to 18 months, hopefully. Are we likely to see a standardized approach in the next 2 to 3 years? Certainly that's the hope, because as Magdalena mentioned, there's a lot of variance in approach. Certainly from the Irish regulatory perspective, we were a little bit surprised at the level of detail that came with the guidance note from the Irish regulator, and I think it's a good sign that they're starting to align, hopefully, with other regulators. But until the e-privacy regulation saga has reached a conclusion, it's hard to predict where we'll be in 2 or 3 years, and hopefully we won't be having to roll back some of the changes that we've implemented to address concerns in this area. So moving on to data subject rights, we'll talk a little bit about the challenges that we're identifying in this area at the moment. Coming from a SaaS business, the issue of DSRs is complicated by the fact that you operate in an organization that is generally a custodian processor for customer data, as well as operating as a controller of data collected independently. This model is becoming more complex in the area of DSRs, just due to the heavy reliance a lot of businesses have on SaaS and cloud solutions. There's still work to be done to make export and deletion of data standardized for customers' ease of use. Often this can be a downside on the principles-based approach to privacy because there's no detailed guidance on how to implement technology to allow ease of access to data and deletion of data. Data access requests in particular present the biggest challenge both for customers when you deal with them and internally for organizations themselves due to the sheer volume of data that can sometimes be involved. The ICO in particular in the past has given several guidances in rulings around proportionate approach to fulfilling DSARs over the imperative of leaving no stone unturned. However, it'll be interesting to watch whether those arguments around proportionality can be sustained as technology catches up to those obligations and starts to deliver more automated methods of pulling and delivering of data. Things to consider when determining how deep you must dig for data right now, would be whether the data is likely to be personal data in the first place, whether data has linkability to other information you hold so that it collectively comprises personal data, and then the level of effort, technical or otherwise, and the resources and costs and other challenges of producing all the data. I'd again, though, reiterate that regulators are likely to take a dim view of an overstatement of technical effort needed to gather data, particularly given that most of the time this will then be a reflection of the systems you've chosen to store the data in, with the full knowledge that you're going to have to fulfill these requests. So, you know, the message being choose your systems carefully when you're doing that. Timing-wise, GDPR does allow for an extension of 2 months, obviously, as we all know, depending on the technical constraints and the difficulties in meeting a 30-day timeframe. This is particularly relevant and useful at the moment, particularly in times of crisis, right now, where we may have to genuinely at some times ask the data subject to bear with us as you work through a request remotely with an entirely or nearly entirely remote workforce. Looking to the right to be forgotten, or the erasure right, since May 2018, I think most organizations with large consumer bases of data subjects will have noticed a rise in popularity of the erasure right under GDPR. In some organizations, these requests have far outstripped the requests to have data access. So it's been interesting for us. We've noticed a lot of third-party tools being used by data subjects to request data. And what we've found when discussing this with regulators is that they do expect you to engage with those third parties, even if they don't meet the criteria you have internally for making data subject requests. You do have to engage with them and try and figure out if there's a way to work around that and facilitate the requests, unless there are overriding or overwhelming security risks involved in that. I'm going to move faster because I think I'm running out of time. Just looking at the global challenges then in relation to implementation of your privacy program and a case for the US. Obviously the US is catching up a little bit in terms of privacy regulation. The difficulty has been, I think, and is going to continue to be, that the US is implementing privacy from a different perspective. As we all know, GDPR is a principles-based piece of legislation. I think the US is approaching it very much from a hybrid perspective. They're looking at privacy with both principles and prescriptiveness in terms of the tone of the regulations they're coming out with. If you look at the Attorney General's regulation from a few weeks ago, coming out to confirm and clarify the CCPA implementation requirements, there was a lot more detail in terms of the granularity of the requirements than there would be under what I've seen regarding guidance from, you know, the EDPP or anything like that. So we're looking at a very different approach, while some of the principles might, from a high-level perspective, be the same. That obviously presents challenges when you're in an online environment because you're trying to implement things, if you can, from a consistent perspective. The other issue is obviously that US legislation tends to approach things from the consumer-based approach as opposed to from the broadly data subject-based approach. So if you're not a consumer and it's a B2B, the relationship you have, then there may be a case where you don't actually have the same rights under the likes of CCPA. And then there's obviously the added complexity of the fact that we're probably going to see a lot more state-implemented privacy laws in the US versus federal laws, and that it pretty much means that they're about 20 years behind Europe, because obviously that was where we were at with the directive, and now they're moving towards that method, which will mean potentially you have to either aim for the highest standard in order to comply, or you have to do a state-by-state approach. Organizationally, applying different data protection standards is not ideal. I liken that to kind of the appetizers approach. You're taking a different approach depending on what meal you're going to have. I think applying a sort of an approach to privacy programs where you take the highest road is sometimes the best approach, but you will probably have to localize a lot more of your websites in the future, especially in the US if you have business there, just because of the nature of how they're approaching privacy right now. And that's not ideal, and it's obviously more costly. So I would very much welcome a more consolidated approach to that between Europe and the US. Very briefly looking at the CCPA guidance from the Attorney General, I think a couple of standouts from that guidance were the fact that in the first round of revisions of the guidance note, they did clarify that IP addresses were not personal information under CCPA. If that business collected the IP address, could not reasonably link the IP address to a particular consumer or household. However, that guidance was left out of the final draft of the regulation, and that does leave us in a bit of a limbo where it's not entirely clear whether an IP address is considered to be personal data in those circumstances or not. And I think that will result again in more inconsistency in approach between US business holders and non-US. They also reiterated that service providers may not use personal information acquired from or on behalf of another business to provide services to another business. And I think this is really mainly about sale of data again, which is a major, major issue under CCPA. So in other words, you can repurpose it if it's just to improve your services, but you can't repurpose it if you're going to then sell it on or augment it out as a service or as a sale in and of itself of an asset. Businesses that do not collect personal information still have to put the point of collection notice on their website. And I think that's really to drive at those kind of data aggregating services, data collection services that don't collect the data directly from the individual, but scrape the internet for the information and things like that. And I think that's very much a welcome introduction, although it's very hard to see how the end consumer is going to actually access that information when it's not always entirely transparent who in fact is receiving their data. And that pretty much brings me to an end in terms of my comments.